if somebody has died because somebody did or didn't do something for them, you are angry and you do want them to be accountable for that in some way.
I know sometimes we are asked whether the family members have a claim on their own account.
I'm just telling you what the law is. It's not what I think it should be, and it's not what I think your loved one's life was worth.
I mean, are there any differences between pursuing a fatal claim and pursuing any other sort of medical negligence claim?
Anyone over the age of 18 who is unmarried, there is nobody who can claim a bereavement award from them. And that seems really awful.
Hello. Welcome to today's edition of Medical Negligence Matters. Today, our subject is fatal medical negligence claims, some of the most emotive claims that any solicitor will deal with. And here to talk about that subject today is my good friend and colleague, Tami Frankel. Hello, Tami.
Hello.
So, fatal claims really, as I said, are some of the most difficult and some of the most emotive cases we deal with. What sort of fatal claims have you dealt with over the years?
It's really wide-ranging because there are many things that can end up killing a person. So ranging from neonatal deaths, maybe babies who are 20 minutes old and die because of what's happened during the course of the labour or not happened during the course of the pregnancy, to people who have had diseases which were not diagnosed promptly and meant they were denied a cure or even just denied the opportunity to prolong their life, to people who have had accidents which have not been treated properly or conditions missed in an accident and emergency context, such as abdominal aortic aneurysms, and maybe their lives could have been changed. It really is wide-ranging.
It's a difficult one, isn't it? Because, of course, death is something that comes to all of us. And what we're talking about in the context of fatal medical negligence cases is cases where that death, really the ultimate injury, happens much sooner than it ought to have done. And I think the impact is enormous, obviously for the individual, but also for all of their loved ones and the people around them. So what sort of person can bring a claim for fatal?
Well, there's a limit to the type of people who can bring, or the range of people who can bring a claim, which is better than it used to be. It used to be that a claim died with the person who'd been injured. But now you can bring a claim if you were dependent in some way on the person who's died, either for their services, broadly what we call services, or financially, and there are certain categories of people within that. There's also now something called a bereavement award that certain categories of people can claim. It's not very much money. I think it's $15,200 at the moment.
No, I think that's right. And I think that is a figure that for many people is incomprehensible, is that it's... And I think it's important for people to understand that the figure for a bereavement award, that fixed figure, isn't in any way intended to signify the value of a human life.
I know.
Because, of course, all of us would say, well, that's incalculable. You know, you cannot put a price on it. And I think that, from a legal point of view, the courts and the legislature has recognised the fact that you can't put a price on it, and therefore they've put in a figure that really is probably just a token gesture.
Absolutely. And it does make it difficult. One of the first things you have to say to clients is, I'm just telling you what the law is. It's not what I think it should be, and it's not what I think your loved one's life was worth, but it's a way of the law recognising that simply the loss of a loved one within these set categories does need to be recognised in some way. But it is difficult for people.
And you're right, you've touched on this earlier. I think the category of person that can claim for that bereavement is itself fairly limited, isn't it?
Yes. I think it's close relatives or people treated as close relatives. But one of the categories which is missed out, which is really awful, is anyone over the age of 18 who is unmarried. There is nobody who can claim a bereavement award from them. And that seems really awful.
That's a very difficult thing to explain to a bereaved
the parents
family,
of a 19-year-old child. I mean, some of the things have improved because it used to be that it was only spouses, so partners who are actually married could claim, whereas now if you've been cohabiting for more than 2 years, you can claim, which of course is recognising a reality of a relationship.
It's a much more modern day,
yeah.
A reflection of how we tend to live.
Absolutely, yeah.
What other elements comprise a claim for a fatal injury, quite apart from the bereavement? What other things can people claim for?
People can claim for, and the biggest parts of a claim will usually be financial losses for someone who was financially dependent on the deceased, and losses of services. Financial losses is usually the easiest to explain because it's generally someone who is living in the same household. You pooled your incomes, and so that pooled income is missing. And we have set ways of calculating how that loss of income that is calculated. Dependency is a bit wider, and it does allow for more people, the reality of that person's relationship with other people to be recognised. So the very common way is, again, within the household, to have the replacement value for the services they provided, such as cooking, cleaning, gardening, those sort of things around the home. But it can also recognise wider services. So if they always had the grandchildren one weekend a month or something, that can be recognised because somebody is going to have to replace those services. And it's in recognition of that and to give some kind of financial recompense for that.
Absolutely. I mean, I think that there are so many things that when one is forced to sit down and think about it and analyse it, that the assistance that we give to each other that goes without thought, really, on a day-to-day basis. If suddenly that individual is not there,
somebody has to fill those gaps.
Exactly, it can be a huge gap in a life. Thinking about evidence, so in terms of gathering evidence in a Fatal Accident Act case, of course, it's complicated in medical negligence, isn't it? Because so many of our clients to begin with are already ill.
Yes.
And I think one of the significant hurdles that we have to get over is proving that the death is something that is the fault or the result of the criticised medical treatment rather than part of that disease process itself.
Yeah. Or, I mean, anybody can get run over. So it is important, yes, to distinguish between someone whose death has been caused by the medical negligence and whose death was going to occur anyway, either, as you say, as part of the disease process or because something else unconnected happens to them and so they die. In either case, you can continue the claim, but the way in which you calculate the ongoing value is different. And in a fatals claim, you will be able to claim for the loss of dependency, the dependency costs, the financial services, whereas you can't if someone dies from an unrelated issue.
Yeah, it strikes me that one of the major differences in a fatal claim as against other types of medical negligence claim, when you're looking at evidence specifically, is the question of inquest. Because obviously in all cases, we would do things like obtaining a complete copy of all the medical records, obtaining a complete sort of statement from the individual as to what had happened, and indeed from family members. But in fatal cases, inquests can often be a very significant part of that evidence gathering, can't it?
Yes, yeah, absolutely. I think sometimes clients place more on what they think an inquest can do for them than it actually can do. It's a fact-finding mission, really. Its purpose is not to allocate blame, and I think people sometimes don't realise that. But in its fact-finding, it can often get us evidence very much earlier than we would have. In particular, if the coroner calls people who were part of the treating team of the deceased, we get to hear those people saying whatever they'd say at that early stage, rather than having to wait till very much later in the process when we get a statement from them, if the defendant even chose to obtain a statement from them. There are times where defendants don't do that, or they've left it so late that clinicians have moved and can't be traced. So it can be really valuable in that way.
Yes, it can be an important part of the evidence gathering process. But I think, as you've touched on initially, I think it's very important that many clients don't really grasp the legal differences between what the lawyer is doing in terms of bringing a civil claim and what a coroner is doing in the inquest process. Because the coroner's jurisdiction is very different. And as you say, it is no part of their role to apportion blame for what happened. I mean, a coroner is purely looking at the who, when, how, and where a death occurred. So most coroners are very wary about going anywhere near dealing with civil or any sort of criminal liability. And the verdicts that can be returned are also very limited. Yeah. And I think it's important for lawyers who are dealing with this sort of case to make sure that clients really understand the difference between the two processes so that they're not disappointed by the outcome of an inquest, which they may feel is, doesn't really deal with their feelings about responsibility.
Doesn't get them what they were hoping to get, because people, especially if you've lost someone and you blame someone else, and you must do, if somebody has died because somebody did or didn't do something for them, you are angry and you do want them to be accountable for that in some way. And I think people do expect an inquest to make someone accountable. And of course, it so often doesn't. And yes, it's part of our job to let them know that at an early stage, to let them know really clearly what we as clinical negligence lawyers can do for them, what the inquest can do for them, and if they really want some other outcome, to let them know what other pathways might be open to them to try and get that other outcome.
I think another aspect about inquest, which I think is quite controversial, is that it can be very difficult for people to get representation for inquests.
Yeah.
It is a very expensive process, and it can feel very unfair, I suspect, really an uneven playing field, because in most medical negligence cases, a hospital, doctors who are involved somehow will have representation provided by the trust or by their defence organisations, and the family can feel very much at a disadvantage. And so I feel quite strongly that wherever possible, families ought to be helped to have representation.
Absolutely.
So that they can feel that the questions are asked.
Exactly, so they can feel the questions are asked. Because as I said earlier, sometimes you can get partway through your claim and find that the defendant isn't even going to be calling the particular doctor, nurse, whoever you feel has questions to answer. And this is the opportunity. There they are in a court, a coroner's court, and they need someone to help them formulate the questions.
And of course, it isn't at all an adversarial sort of process, and it's important to stress that. And I think where a family is being represented, the value of that really is in assisting the coroner, in my view, to actually to get all the evidence out and to assess that evidence and to make sure that nothing is being hidden or overlooked. In terms of the process of pursuing a claim, once the evidence has been gathered, I mean, are there any differences between pursuing a fatal claim and pursuing any other sort of medical negligence claim?
The process of it is pretty much the same. I mean, you'll usually have to get a grant of probate of some sort so that someone has the legal standing to bring the claim, but the process is pretty much the same. In terms of the type of evidence you might be gathering, you'll probably have more evidence from individuals, because you'll need to evidence what the income was, the household income, if you're looking at a loss of financial dependency, and about the services you're claiming for. And that can be unusual. We don't often have lots of factual witness statements in our claims, but I'm not sure, there's not really that much difference otherwise.
Actually, just picking up, it's a very important point that you've raised, I think, about the probate, because, of course, many people these days, unless you're leaving significant amounts of money or assets, most people don't need to bother with either getting a grant of probate if there's a will or a grant of letters of administration. And that is something that the lawyer should advise on, isn't it? And it can be quite an expensive thing to do, but of course it is certainly if someone left a will, then you get a grant of probate. But if someone didn't leave a will, it's actually you have to have the grant of letters of administration before you can commence proceedings. So it is something that people
you've got to have on your radar.
Is unique to these types of cases. What do you think? Is there any difference, you think, in acting for the individual clients in a fatal case as opposed to any other sort of medical negligence case? Any particular demands or needs, do you think?
I suppose one big difference is the person you're acting for is not the person who was injured by the treatment, and yet they're the person left behind and they've been injured in a wholly different way. So they are never physically injured by whatever has happened and gotten wrong. But of course, they are emotionally probably devastated, because usually the person who comes to see you is a close relative, someone who cared about the deceased deeply. So they do have emotional needs which are different in some ways to the injured person themselves. The injured person themselves, when they come to you in a other claim, obviously will have an emotional impact. But in this one, their whole life has been changed by having someone central removed from it at a time when they really shouldn't have been. Yeah.
I know sometimes we are asked whether the family members have a claim on their own account for the trauma that they've suffered. And that's really difficult, isn't it? Because the answer, and we'll cover this in other episodes, but the answer fundamentally is no.
Yeah, and that's difficult to say. I mean, there are lots of areas of our jobs where we have to explain to people, you just can't, it seems unfair. We're just explaining at the beginning the rules and regulations, what you can and can't achieve, really to help people with their expectations right from the beginning, so that they know what we can do for them and what we can't do for them and how we'll do it.
Yes, I mean, I think it is one of the most challenging things for lawyers in this field is to enable people to feel that they have some sort of justice, where in reality the rules can make it feel very unjust
Very
indeed.
different, yeah.
And I think you always got to have that in the back of your mind. And so I guess that the best that we can achieve in these circumstances, and certainly in financial terms, is trying to replace the earnings that the individual provided for the family, to try and put the family back, I guess, into the financial situation that they would have been in had they not suffered the loss of that family member or friend. And so what types of compensation can we get for an individual client in these cases?
Well, if they're the spouse or someone who is financially dependent in that they pooled their income in some way, there are set formulas that are usually followed. You sort of you have to evidence what their household income was prior to the death and what it is now, where the difference lies. I mean, actually, there are a couple of types of payments that are ignored, so that benefits, it seems awful to call it a benefit, but a benefit, financial benefit, which comes to someone who's still living as a result of the death, such as from an insurance policy, is ignored for this purpose.
So you don't have to give credit for that?
No, you don't. It's been decided that if someone's been sensible enough to look after themselves in that way, the defendant isn't going to make a profit by not having to recompense the remaining family members for what's been stolen from them. And in terms of services, it can be more difficult because people, as you said, people don't often think, sort of if your husband goes and mows the lawn, or, your daughter, somebody looks after a grandchild, you don't think of that as a service. You think of that as part of family life, give and take, the way things are. But of course, if that's ripped away in all its pieces, it has to be replaced in some way. Somebody fills those gaps. Lawns still get mowed, children still get looked after. And sometimes asking people to think about those things, it's good to have a meeting with them at the office where you can talk about it, let them go away and think about it, because that's when things start coming to their minds, and then letting you know the things that were done. I mean, it can be a once a year thing, sort of taking the grandchildren away for a week, which gives the parents, sort of their children a break or something.
It suddenly occurs to me, the other thing we probably ought to mention is the fact that there is the Bereavement Award, as we've already talked about, for a limited number of people. There is also, where a child has lost a parent, there is also a sort of a notional sum awarded, isn't it, for the loss of that loved one. I mean, again, it's the sorts of figures that no one would regard as being a reasonable recompense, but it is something that's available, there to be included as part of the claim. And then thinking really about sort of moving forward after bringing a fatal medical negligence claim. I mean, as in all cases, I suppose that what we were aiming for is, firstly, as I said, putting the family in a financial position that they would have been in were it not for the loss, but also I think maybe having a sense of resolution and the ability to move forward. And I don't know, in your experience, have you felt that people have been able to sometimes, I don't know, maybe do something with the money that they've got as a memorial or as something that they can feel is a more positive outcome?
I mean, I think memorials themselves are a thing that most families do want, some sort of, even if it's just a plaque, so the deceased was cremated, a plaque. There are instances where people set up charitable foundations. It's difficult to be too specific because we don't want to end up identifying any of our clients, but people do sometimes do things such as setting up charitable institutions or helping out at charities that are aligned with whatever happened to their loved one. So yes, there are lots of ways in which people do try and not allow the death to have been in vain. I think people sometimes think that way about it. They don't want it to have been in vain. They want something positive to have come out of it.
Absolutely. I mean, something that is, yes, a positive thing, something that enables them to remember that individual loved one with some positivity and purpose. And yeah, that's what we would hope to aim for.
Yeah, absolutely.
Well, thanks, Tami. We've covered an awful lot today, but I'm grateful to you for your help with this.
Thank you.